Hello and welcome to Courts Today by LiveLaw. Let us start with today's top headlines. Regarding the Manipur crisis, the Supreme Court has today asked the state to furnish details of buildings burnt, looted and trespassed and the action taken against violators. Journalist Chitra Tripathi has moved the Punjab and Haryana High Court against arrest warrant issued by Gurugram court in a POCSO case. The Punjab and Haryana High Court made a WhatsApp video call to a police station to ascertain whether the accused joined cheating probe or not. The Rajasthan High Court has overturned a 22-year-old acquittal in a dowry death case and said that the woman died within 4 walls of the in-laws' home and was cremated hurriedly. The Bar Council of India has suspended Bar Council of Delhi's vice chairman over alleged fake LLB degree and has resolved to refer the matter to the CBI. In a plea to apply the POSH Act to political parties, the Supreme Court has asked the petitioner to approach the Election Commission of India. The Apex Court, while hearing West Bengal's plea against the High Court's quashing of OBC classifications, said that reservation cannot be on the basis of religion. And the top court has said that in quashing petition, there is wider challenge available than discharge petition. I am your host, Urvashi Chauhan, with your daily roundup of legal updates from across the country. Before we move ahead, LiveLaw Academy is offering a value-packed opportunity for aspiring judges. The Judicial Service Examinations Preparation Course. This 18-month comprehensive online course is designed to help you prepare for your judiciary exams. Classes are conducted by expert faculty, including retired judges. You would learn from actual case studies and other easy-to-follow study materials. And all of this comes at a very affordable fee. If you are gearing up for the judiciary exams, this is a must-check opportunity. Enroll today and get 25% scholarship. You can check all details at www.livelawacademy.com. The link is also provided in the description. The Supreme Court bench of CJI Sanjeev Khanna and Justice Sanjay Kumar has asked the Manipur government to furnish in a sealed cover a list of properties which have been burnt, looted or encroached upon amidst the ongoing ethnic clashes in the state. The bench was hearing the matter relating to the Manipur ethnic violence crisis. Senior advocate Vibha Makhija informed the court that the Justice Geeta Mittal committee has prepared over 34 reports on its tasks. She highlighted the committee's progress and key humanitarian achievements, noting that it has worked pro bono, providing rehabilitation, offering hospitality, building skills, and helping people reclaim their properties. The court directed the committee reports to be filed to enable the Home Ministry and the state government to take remedial action. Taking into consideration the grievance of displaced persons and their properties which have been affected due to the conflict, the bench directed the state government to submit a sealed cover report detailing the burnt, looted, trespassed or encroached buildings along with the names and addresses of the owners and occupants. The report should also outline actions taken against trespassers as per the law. The state government was also asked to respond to the issue of release of funds for temporary and permanent housing as flagged by the Mittal committee. TV news anchor and journalist Chitra Tripathi, who currently works with ABP News, has moved the Punjab and Haryana High Court, challenging an order of the Gurugram court which issued a non-bailable warrant of arrest against her in connection with a POCSO case. In this case, charges have been framed against 8 journalists, including well-known anchors Deepak Chaurasia and Ajit Anjum, for allegedly airing morphed and obscene videos of a 10-year-old girl and her family. The videos were falsely linked to a sexual assault case involving the self-styled godman Asaram Bapu. The accused media professionals, including anchors, reporters and producers from News 24 and India News, face charges under various sections of the IPC, IT Act and POCSO Act for criminal conspiracy, forgery and the illegal representation of a child. The charges allege that the journalists conspired to forge and edit the video to harm the reputation of the girl and her family. They are accused of broadcasting the altered video depicting the girl and her family in an indecent manner. In a recent development, let me tell you, the Punjab and Haryana High Court had set aside a trial court's order that had cancelled the bail of Republic Bharat anchor Mohammad Sohail, who is also implicated in the case. The court directed Sohail to surrender before the trial court by 12th December and apply for regular bail. In Chitra Tripathi's case, the court had cancelled her bail plea and rejected her request for exemption from personal appearance. Her anticipatory bail plea had also been dismissed last month. Also, the additional district and sessions judge ordered the SHO to execute the arrest warrant, and if unexecuted, he was to appear in person before the court. When the warrant was not executed on 30th November, the court issued another arrest warrant. Now, challenging both the arrest warrants, Tripathi has approached the High Court, explaining that she missed the November 13th appearance because she was travelling to Nashik for election coverage and an interview with Deputy Chief Minister Ajit Pawar. But the court rejected her explanation and issued a non-bailable warrant. A bench of Justice Nidhi Gupta heard her plea last week and an order is awaited. In an interesting development, the Punjab and Haryana High Court used WhatsApp video call to resolve a dispute over whether the accused individuals in a cheating case who had been granted anticipatory bail had joined the investigation or not. During the hearing, the State Council claimed that the accused had not joined the investigation, while the accused's lawyer argued that the police was preventing their clients from doing so, even though they were present at the police station. To resolve the issue, Justice Sandeep Mudgil directed the station house officer to connect via video call. During the call, the SHO confirmed that the accused were present at the police station and had joined the investigation. He also said that they were not required for further custodial interrogation. The court noted that the issue of conflicting statements from both sides had led to the video call. The case was then disposed of after the SHO's confirmation. Overturning a 22-year-old acquittal in a dowry death case, the Jodhpur bench of the Rajasthan High Court has cancelled the bail bonds of the accused father-in-law and the mother-in-law, noting that they failed to explain the circumstances leading to the woman's death, since the alleged crime took place within the four walls of their home. The court pointed out that after the victim's death, the accused rushed her cremation without informing her family or the police, preventing a post-mortem. This behavior suggested an attempt to conceal evidence and fabricate a story to protect themselves. The bench also noted that the trial court misread the evidence and took a hyper-technical approach in evaluating the witness testimonies. This was considered inappropriate, particularly in cases involving social welfare issues such as dowry deaths, which are deeply rooted in Indian society. The court referred to the Supreme Court case of Chabi Karmakar and others versus State of West Bengal, which outlined the four essential elements to prove dowry death. Number 1, death caused by burns or bodily injury. Second, should be within 7 years of marriage. Third, harassment should have occurred soon before death. And number 4, harassment should be related to dowry demand. The appellant side argued that the victim was continuously harassed by the accused over insufficient dowry, that 2 months before her death, she had mentioned the ongoing harassment during a visit to her matrimonial family. The court referred to previous Supreme Court decisions that outlined the 4 essential elements to prove dowry death. Number 1, death should be caused by burns or bodily injury. Number 2, death should occur within 7 years of marriage. Number 3, harassment should have occurred soon before death. And number 4, harassment should be related to dowry demand. The court reviewed the records and determined the first 2 elements were met. Regarding the third one, it clarified that soon after is relative and harassment need not be immediate but should not be too remote. So the court concluded that despite the victim's visit 2 months before her death to her parents, the ongoing harassment established a proximate and live link between the cruelty and her death. Thus, the accused were sentenced to imprisonment, cancelling their bail bonds. Practicing law with a fake degree is a grave offence in our country, leading to both criminal and professional consequences. It can attract charges of fraud, cheating and forgery under the IPC, with penalties including imprisonment of up to 7 years and fines. Professionally, the Bar Council of India can disqualify the individual, cancel their enrollment and permanently bar them from practicing law. The Bar Council of India has suspended the Vice Chairman of Bar Council of Delhi, Sanjeev Naseer, due to alleged irregularities in his law degree. It has also decided to refer the matter to CBI for investigation. The entire matter started from a writ petition filed by Naresh Chand Gupta, a practicing advocate who alleged that Sanjeev had enrolled as an advocate using a forged LLB honours degree. He highlighted inconsistencies in Sanjeev's academic documents and cited an earlier case involving forged degrees from the same university. Before the Delhi High Court, the university initially confirmed the authenticity of Sanjeev's degree. The court observed that despite BCI's request, the Bar Council of Delhi did not share the relevant records. It then directed the BCD to submit all records to the Bar Council of India for further action. Following an inquiry, the BCI found inconsistencies in the university's response during the verification process. A subcommittee was constituted in September this year to look into Sanjeev's academic credentials. The committee uncovered some major discrepancies, like the unauthorized status of the LLB honours program at PMB Gujarati Arts and Law College during the relevant period, tampered records from Devi Ahilyabai Vishwavidyalaya, and the fact that LLB honours course was introduced only in the year 2008, while Sanjeev's degree was dated 1988. Non-cooperation from the university officials further cast doubt on the degree's authenticity. The BCI has now resolved to refer the matter to CBI so as to preserve the integrity of the legal profession and public confidence in the bar. Moving ahead, the Supreme Court has today disposed of a PIL seeking application of Sexual Harassment of Women at Workplace Act 2013 to political parties by asking the petitioner to first approach the Election Commission of India. The PIL filed by a Supreme Court lawyer had sought to direct political parties to set up internal complaints committee under the POSH, declare party members as employees under the Act, make POSH compliance mandatory for political parties' registration, and ensure regular reporting and public disclosure of the committee's functioning. During the hearing, the bench of Justice Suryakant and Justice Manmohan pointed out that the Kerala High Court, in a judgment, had held that political parties are not bound by the POSH Act, and that judgment had not been challenged. When Justice Kant inquired about the legal status of a political party, senior advocate Shobha Gupta replied that they are registered entities as per Section 29A of the Representation of Peoples Act. Justice Kant then observed that Election Commission of India was required to be made a party in this case, as it was the competent authority with respect to political parties. The court then suggested that the petitioner should approach the ECI and then come back to the court based on their response. Accordingly, the petition was disposed of. The Supreme Court today heard the petition filed by State of West Bengal challenging the decision of the Calcutta High Court to quash the OBC classification of 77 communities, mostly belonging to Muslim religion. In May this year, the High Court had delivered the verdict in a plea challenging the process of granting OBC certificates in the state. The plea challenged certain provisions of the West Bengal Backward Classes Act of 2012, which made reservations in public offices for those belonging to the OBC category. In its order, the High Court struck down several classes for reservation as OBC given under the Act. The state of West Bengal has challenged the decision before the Supreme Court. Hearing the petition today, the bench of Justices B.R. Gawai and K.V. Vishwanathan remarked that reservation cannot be given on the basis of religion. To this, the counsel for the state, senior advocate Kapil Sibal, said that reservation was granted not on the basis of religion, but on the basis of the backwardness of the communities. Backwardness exists in all communities, he said. He also said that there was quantifiable data that this affects a larger number of people, including students. Sibal sought interim relief, highlighting that about 12 lakh OBC certificates have been cancelled as a result of the High Court's judgment. Senior advocate P.S. Patwalia, representing the respondents, countered the arguments. He stated that reservation for 77 communities was granted without any data or survey and bypassed the Backward Classes Commission. He pointed out that the reservation was introduced after a statement by the then Chief Minister in 2010 without consulting the Commission. In response, senior advocates Sibal and Rakesh Dwivedi, representing the state, argued that a survey report was conducted and annexed with the petition to support the reservation policy. During the hearing, the bench questioned how the High Court could strike down Section 12 of the West Bengal Backward Classes Act 2012, which grants the state the power to identify classes. Justice Gawai pointed out that as established in the Indira Sohne case, it is the executive's authority to classify, and asked if the potential misuse of a provision alone was sufficient ground to invalidate it. After this, the matter was adjourned to 7th January for a detailed hearing. Stay tuned. And lastly, the Supreme Court has shed light on two important concepts of criminal law: the discharge petition and the quashing petition. A discharge petition is filed before the charges are framed by the court. The purpose is to seek discharge from the case because insufficient evidence or material is there to proceed to trial. Here, the accused claims that no offense is made out against him. The discharge petition can be filed at any stage, directly in the High Court. It is used to quash an FIR or criminal proceedings, arguing that the case is frivolous, malicious, or an abuse of the legal process, etc. The petitioner can claim lack of jurisdiction or a compromise between the parties. In this regard, the top court has reiterated that an accused can still file a petition to quash criminal proceedings even after filing a charge sheet. It rejected the argument that the accused must wait for charges to be framed and then challenge an order framing charges through a revision application. The court explained that in a quashing petition, wider grounds of challenge would be available than in a discharge petition. The bench, comprising Justices Abhay S. Oak and A.G. Masih, heard the appeal filed by the accused against an order of the Allahabad High Court, which dismissed his quashing petition, saying that it was infructuous after a charge sheet was filed against the accused. During the proceedings before the Supreme Court, the counsel for the state of Uttar Pradesh contended that once the charge sheet was filed against him, the accused could have waited until the charges were framed to challenge the order of framing charges through a revision application. But the court did not accept the argument. It clarified that the scope of a discharge application differs significantly from that of a quashing petition. In a discharge application, the accused cannot rely on documents outside the charge sheet nor argue abuse of process of law. However, in a quashing petition under Section 482 of CRPC or Article 226 of the Constitution, the accused can challenge proceedings on broader grounds, including abuse of process, and rely on additional documents. Since the High Court had not examined the appellant's quashing petition on merits here, the Supreme Court set aside its order and restored the case for a hearing before the High Court.